Mr. Chairman, we are live.
All right, welcome to the March 18th meeting of the House Judiciary Committee meeting. We'll be considering 3 bills today. Okay, will you call the roll?
Representative Crago.
Here.
Representative Larson.
Here.
Representative Oakley.
Here.
Representative Provenza.
Here.
Representative Williams.
Here.
Vice Chairman Washut.
Here.
Representative Yin.
Here.
Representative Swanitzer.
Here.
Chairman Olson.
Here.
Mr. Chairman, there are 9 present.
Thank you. Okay, committee. So I'm going to take these bills a little out of order again. We're trying to match with Senate schedules that are changing, and Senator Cost has a bill up same time in TRW. So I've agreed to hear his bill last in order to give him enough time to get his TRW bill out of the way. So what we're going to do is House Bill 82, then we'll do Senate File 96, and then we'll go to Senate File 87. House Bill 82, already on the committee's consideration. We held public comment on House Bill 82. We closed public comment, and we had, if you recall, House Bill 209 simultaneously. We pretty much ran it down to the end of the clock. We had a motion on 209, some discussion, and frankly, I think we just ran out of time on House Bill 82. So I wanted to reschedule that, and here we are for House Bill 82. And committee, I'd ask you for your pleasure on the bill.
Mr. Chairman, move the bill.
Moved by Representative Yin, seconded by Representative Provenza. Is there any amendments on this bill? Or discussion on the bill? Vice Chairman Washut.
Thank you, Mr. Chairman. I would urge the committee to have a no vote on this bill at this time while we have 209 still in play, because I believe to go before the body and make a recommendation to affirmatively consider this legislation when it really is not line up very well with 209. This bill calls for basically a study and recommendations and all sorts of things that are already presupposed in 209. So I would encourage the committee not to bring this bill forward until we have a resolution of 209.
Representative Swanitzer.
Thanks, Mr. Chairman. I'd like to make a motion on page 3, lines 9 through 20, delete the entire section.
You want to delete the? So
I want to delete all of section 2 and then renumber section 3 to section 2.
Okay, you're deleting the appropriation.
I am deleting the appropriation.
Second on the motion, seconded by Representative Crago. Discussion on the appropriation.
Oh, Mr. Chairman, in
It saves
fairness,
a re-referral.
so the committee, the process would be if this bill passes, it has to go to appropriations, which then would take 2 more days. The last day to get bills on committee of the whole will be Monday or possibly Saturday. And so it's a weird procedural move to skip appropriations and then we can fight it on the floor with an appropriation. It just saves the bill 2 days. So if you don't like the bill, you probably don't want to vote for my amendment. If you do like the bill, you probably do. And plus, I don't think it needs 30,000. We can have them do the study and they'll find the money.
Yep, I think it's a good amendment for the timing purpose of getting this bill onto the committee of the whole on Monday, which is the last day, committee of the whole, or tomorrow. Vice Chairman Washut.
You know, I'm pretty tight the taxpayers' money, but I do think that this is a real important deep dive into this issue, and there ought to be an appropriation for it. So the agencies can do a quality job, and you know, the good bringer of the bill wouldn't have put this appropriation in there if it wasn't necessary. And so I think we as a committee should keep the appropriation in there and so that the funding is there so the committee can do what it needs to do, or the study group can do what it needs to do and do it well.
All those in favor of the amendment signify by raising your hand. All those opposed, wait, 1, 2, 3, 4. 1, 2, 3, 4, 5. That amendment fails. Representative Henderson, this committee or task force, it's a study done by the state health officer, Department of Health, Board of Pharmacy, State Board of Medicine, State Insurance Commissioner, Attorney General. They're going to develop the report. There's no legislative liaisons on this. Would you be opposed to adding legislative liaisons to this?
No, Mr. Chairman. I think that would be reasonable to consider. If I might take a little bit of a privilege and refer back to the discussion on the appropriation.
Sure.
You know, given the deadlines, this was how a previous bill that I was able to get enacted into law actually survived through the deadlines. And so we don't have a crystal ball on the one that your good committee worked the other day and passed on to the floor. And so I think I would ask for maybe reconsidering that, but that's just my view. But certainly have no problem at all with the committee. You know, this is a starting point. I think we need to consider the testimony that we've had, and it'd be a good opportunity to amend this as necessary to fit what you feel is most important that should be in this deep dive. And then this would provide perhaps a backup for the committee going forward into the interim. Thank you for the question, Mr. Chairman.
Okay. And I'm trying to figure out if we added liaisons, I mean, it's not really, it's just saying a report has to be done. It's not really directing that there is a body being created to do the report.
Not really asking for anything policy.
So I'm trying to figure out how to keep the legislature involved in it. That's my chief concern, is how do I keep the legislature involved in this? Which would be it's a report, but it's a policy decision. And I think the legislature should be involved in it. Do you have a thought on how we do that, Representative Henderson?
Yes, I do. Thank you, Mr. Chairman. So as I said, I think this could be written however you wish it to be written. It could be written as a substitute bill, frankly, and in the form of a committee incorporating the legislative participation that you refer to. But more importantly, maybe some of the things in the larger bill and the regulatory aspects of it, law enforcement, whatever. I didn't put that in here. But in my conversations with the public, with the person who manages or oversees or helps us with public health, the individual said that the only concern was the deadline of the report. And changing that, my perception is the agency and the other boards are ready to do what they need to do to help us to make sure that we know where we're headed and doing the right things for Wyoming in this important area. I'll mention another area that I think is very important that I didn't put in there is substance abuse, right? And perhaps even more pointedly, the area of the use among our young people. You know, 45% of our young people are using this substance in schools. So,
Representative Zwanitzer?
Thanks, Mr. Chairman. I guess, and I'm sorry I missed most of the committee hearing last week, but I need to ask a question. Why on page 2 is the report due September 30th, 2021, but you're leaving the appropriation in place for another year? I can't figure out why you'd want to have money available after the report is to be given.
Mr. Chairman?
Yeah.
Thank you, Mr. Chairman, and thank you for that question, Chairman Zwanitzer. It's because the whole purpose of doing this and spending the time is to prepare and help inform the legislature for the following session. And so the original one, I had an amendment ready to go to modify that to a preliminary report. And then the other part of my amendment had to do with because it's a Schedule I substance, changing prescription to recommendations and recommending provider. But the dates are to help inform the legislature. The one at the end of this year for the next session. The final one at the end of, I think it's September of next year, to help inform us for the next general session. So I think by that time, with all the discussions that your committee is likely to have related to this, I think it's just trying to synchronize or have these dates so that they make some sense as far as preparation of the report and distribution.
I think would be an appropriate amendment would be on page 3 on the report requirement. The state health officer shall provide the report to the Joint Labor, Health and Social Service Interim Committee.
Oh,
I think the Judiciary Committee should receive that report.
Mr. Chairman, thank you. That's an excellent point. My initial thought was because of the labor and health and welfare related aspects of this, but also importantly, it should be also the judiciary. And I would leave it up to your good offices to decide which should have priority in terms of oversight.
Both can receive the report.
Yes, sir.
Okay. Committee? Any other discussion, amendments? Question? I mean, I've got a lot of thoughts on this bill in terms of things that I might, but I will just work it on the floor. I think in terms of the amendments that I'm thinking in my head, I think I'm comfortable with that.
Mhm.
So I think my priority would be to get the bill out to the floor.
Well, that's my priority too, Mr. Chairman, is to get it out to the floor, because if it doesn't get there, it doesn't go any further. And then of course, we don't have a backup for the other aspect of this. So, and it'll be up to the body to decide how far that goes, of course. But I think there's a lot of aspects to this that warrant a deeper look before we make the important decision to go to the next step. That's my view.
Oh, Representative Zonitzer?
This is probably a question for the chairman. So page 3, this report's being sent to the Labor, Health and Social Services Interim Committee, not the Joint Judiciary Interim Committee. And I guess I don't know the expectation if the chairman believes this will be an interim study in this committee or in Labor Health. So I guess I'm asking the chairman if it would be better to be sent to this committee if this committee is more, I don't know what you're asking for in the interim, but if you're asking for marijuana topics, I would say the report should probably come here.
Yeah, sorry, that's what I was trying to say. I want to amend that to be our committee. I am working with leadership in the Senate right now to have a solid interim topic of medical marijuana. And I really feel good about that. And I think that's going to be judiciary. It could be labor health, I suppose. But I think at the very least, we should send the report to both just to cover our base. There's no harm. This is a report, I suppose. You read it. We consider it. And
Do you want to make that motion, Mr. Chairman? I'd be happy to.
yeah, please do.
I would move on page 3, line 6. We add Joint Judiciary Interim Committee.
And corporations.
Tempting, but probably 2 committees is enough, Mr. Chairman.
Okay. Moved by Representative Zonitzer and seconded by Representative Yin. Discussion on the amendment? Question on the amendment? All those in favor of the amendment signify by raising your hand. All those opposed, that amendment carries.
Chairman Olson, could you read that one more time for me,
Oh,
please?
yes. Okay, so on page 3, line 5, let's see, line 5. In front of the word joint and between the, insert joint judiciary committee, comma. And then it would follow joint labor and joint labor health social services.
So insert joint Senate
No,
Judiciary Committee.
Just joint judiciary committee,
Okay,
joint judiciary committee
okay,
after the, oh, yeah, joint judiciary interim committee. I'm sure LSO can play with that because it could also just read joint labor, joint judiciary and labor, health and social services interim committees, or however they want to
Okay.
do that, but just trying to get 2 committees in there.
okay. Thank you.
Yep. Just joint committee. All right. We could have a joint meeting between labor, health and judiciary. Vice Chairman Washit.
Thank you, Mr. Chairman. I just wanted a point of order whether or not my previous call for the question was out of order.
Oh, I thought you called the question on the amendment. Did you call the question on the bill?
We didn't vote on either.
We voted on this amendment. We voted on this amendment. It was 7-2. This amendment to add joint judiciary on page 3 was 7-2 vote. And then Kay asked for clarification of the amendment. Now we're back on the discussion of the bill. Additional discussion of the bill, amendments on the bill. Representative Provenza.
Thank you, Mr. Chairman. I guess I would urge the committee to put this bill up to the floor in the event that the other bill isn't read, just given that we had a ton of public testimony and public outcry for this. It seems that the public wants to have this conversation, wants to continue this, and so making sure that we provide for that. Thank you.
Thank you. Vice Chairman Washit.
Thank you. Just to reiterate, Mr. Chairman, that, we're going to go to the microphone and we're going to recommend to the body that they do pass House Bill 82 after we've already given a recommendation that they do pass 209. And the 2 bills really don't jive with one another. One is asking for a study and the other one is, implementing legislation and moving the ball down the field. And I really don't think that they're compatible with one another. And so I urge the committee to, vote no on this because we've already voted 209 to the floor. And I think that to take a second bill that's inconsistent with the one that's already been introduced, it's just inappropriate and problematic.
Representative Williams.
Thank you, Mr. Chairman. I echo the same concerns as Representative Washit. And just to further elaborate on Representative Provenza's concerns as well, I think that we didn't allow enough time for public testimony on this bill, specifically this bill. Yes, we have heard a lot of public outcry, but I can speak to the fact that there were several of my constituents that did not make it through Zoom to testify, or did not make it here in the audience to testify in opposition of this bill specifically. Further, I have concerns that this bill isn't quite ready to be moved.
Okay. All right. Representative Zwanitzer.
Thanks, Mr. Chairman. I just want to double check. The bill was referenced for today, and I don't know if you asked if there was anyone in the waiting room who wanted to testify, but was public, I missed last meeting. Was public comment definitely shut off and closed? Okay.
So, yeah, we had 4 hours of public comment on House Bill 209 and 82. And at least in my time on the judiciary and on the appropriations, I've never had public comment open on 2 bills for 4 hours.
Oh,
So that was a lot of public comment, but
you're lucky.
it's a lot of time.
Oh, so Mr. Chairman, I would just say, I think this bill is fairly different than the other. This is just asking for data and a study and a report. And I trust the majority floor leader will put either or both or neither up at his discretion on making it work. So I trust that he'll either put them up or hold them back or choose one, and we'll get to debate it.
Okay, sounds good. I think this bill's pretty Although it deals with a report, its implementation requirements for medical marijuana and its bill title can be amended and the bill can be amended. This doesn't have to be a study bill, just my observation. This could be a medical marijuana bill. It could be that. So I don't think that they're opposites. I think that they're choices, policy choices that we're providing the body with regarding recreational marijuana HB 209 and medical marijuana HB 82. And I think the body could decide which direction it wants to go, if any. And maybe it ends with the idea that it just wants to study it. Maybe it wants to implement marijuana medically in the state of Wyoming now. And this is the vehicle to do it. And it can be amended to do that. Representative Williams.
Thank you, Mr. Chairman. Just to push a little bit back on that, I obviously am opposed to this bill, and I have a problem with using taxpayer dollars state taxpayer dollars to fund a study bill on a Schedule I drug, a drug that's listed by the DEA as a Schedule I drug. I don't think it's the place of this body to use taxpayer dollars for such a thing.
Was that
Thank
a
you.
motion to remove the appropriation?
No, sir.
Oh, we tried that. I think you voted against that, but if you want to try again, we can. Then there would be no taxpayer dollars. Just an observation.
Mr. Chairman.
Yes.
If I may, just for the backup information for the committee, during the process of developing this bill, I had many people contact me with a range of interest, particularly those who are currently in treatment for things like cancer and so forth, and wanted to come forward and testify. And I thanked them respectfully and asked them, given I knew there was going to be a lot of interest in this subject, that if this made it along in the process and into the interim period, that would certainly be an opportunity for everyone who has a concern across our state or an input or interest in this would have certainly an opportunity to come forward and make their thoughts known. So people who want to set up businesses contacted me. As I say, it's a full range. And I'm sure you were contacted as well in your preparation. So, and we heard that in the testimony. So my recommendation would be to, as a committee, decide how you feel it best to develop this going forward and arrange it the way you think it should be arranged. But I think it has merit in terms of the public interest and the need for discussing this important topic in our state.
Representative Oakley.
Thank you, Mr. Chair, and thank you, Representative. I guess I just wanted to throw in there, it is a concern, certainly to me as well, that it's a Schedule I. So at this point, federally prohibited drug, but I know also we don't operate in a vacuum, and we don't have to act as such. And there's certainly indication that it will be delisted as a Schedule I drug. I mean, I think we can probably fairly confidently look that the federal government might do that. And so I really appreciate what Representative Henderson said when he testified last time, and to the intent of this bill, which is, if this is something that's coming and we're going to have the discussion on medical marijuana, let's start learning, understanding, and having that discussion. And I think that this gives us the opportunity to do it. And so it's tough, because is it putting the cart before the horse? Possibly, but I also, again, appreciate what you said before. If not, then we're just unprepared when it does come. So, I do appreciate the intent of the bill and the opportunity for us to start discussing what does medical marijuana look like for our state. So, thank you.
All right, sensing Vice Chairman Washut wants the question. Okay. Okay, will you please call the roll on House Bill 82, implementation requirements for medical marijuana?
Representative Crago,
Aye.
Representative Larson,
No.
Representative Oakley.
Aye.
Representative Provenza,
Aye.
Representative Williams,
No.
Vice Chairman Washut,
No,
Representative Yin,
Aye.
Representative Swanitzer.
Aye.
Chairman Olson.
Aye.
Mr. Chairman, you have 6 ayes and 3 noes. The noes being Representative Larson, Representative Williams, and Representative and Vice Chairman Washut.
Thank you, Representative Henderson. Okay. Senator Hutchings, we're going to take yours up next. Senator Cost is presenting a bill in another committee, so I've moved you forward. And I'm going to allow for, I'm going to send one of your co-sponsors, Representative Oakley, down there to hang out with you. Okay. All right, Senator, will you introduce us to your bill and just take us through it how you want to?
Thank you, Mr. Chairman and members of the committee. I really appreciate this opportunity to come before you today. This bill means a lot to me and several members of our legislature. This bill is about murder, and nothing else. It's about first and second degree murder. According to the Center of Disease Control, murder is the #1 cause of death in pregnant women. I spoke to our nationally certified coroners, DAs, and prosecutors around the state about this and got their input to help create what I believe is a great bill. Currently, you have 3 members of the 66 that have been affected by this crime. There are several instances of this crime here in Wyoming, and our current Wyoming statute 6-2-109, the sentencing enhancement, is just not adequate. Since 2004, our federal government has passed this legislation. For over 35 years, 38 states from coast to coast have enacted this law. This bill will create a dual homicide for killing a pregnant woman. So we can go through the bill. Unless you have something you want to interject, just let me know anytime. Okay. Bill homicide amendments, page 1. We're creating, it's related to crimes and offenses, creating a new offense for first and second degree murder. If you go to page 2, we have our definition. This is not the definition I picked. One of the DAs picked this definition because this is the definition that's in our federal law right now. So page lines 2 through 8 on page 2 give us the definition of an unborn child. We go to lines 13 through 23, and that talks about first degree murder. This is a really simple, straightforward bill. A person is guilty in the first degree if they murder an unborn child while attempting to kill the pregnant woman. On page 3, they're guilty on lines 5 through 21. They're guilty of second degree murder if they try to kill the mother, maybe not kill the mother, but again, kill the unborn child. It's as simple as that. We're creating a murder charge for the unborn child in this instance. And that is pretty much the bill in its entirety. I'll let Representative Oakley speak and then answer any questions.
All right, thank you, Senator Hutchings. Representative Oakley.
Thank you, Mr. Chair. I guess I'm not going to add anything or say anything at this time. She's walked through the bill. I do have some understanding, of statutes in criminal law. So if we get into that, I will certainly speak to that and take any questions. But I don't have anything to add at this point.
committee. Vice
Oh.
Chairman Washit.
Thank you, Mr.
Oh, I'm
Chairman.
sorry, Senator Hutchins, were you gonna say something?
Yes, if you don't mind, Chairman and Representative Washut. Just quickly, I wanted to just relate to the body what this is really all about. We had a Representative Davison. Gosh, I think she was in, when I was in the House in 2012, 13, 14 timeframe. And she had a daughter that was murdered by her husband and she was pregnant. Her daughter happens to be the best friend of Representative Oakley. I didn't find out that until I was seeking her advice on the bill and found out she was the best friend and got her as a co-sponsor. Senator Baldwin is raising Representative Davison's grandson because his father is sent to prison and his mom and his sibling were both murdered. And I have a personal experience with this where my cousin, her husband stabbed and killed her when she was pregnant, but only spent, I think, 3 or 5 years in prison. So that's the background behind this and the personal nature of it and how the legislature is involved. So that was just a little side note, FYI for you. Thank you, Mr. Chairman.
Thank you. Vice Chairman Washit.
Thank you, Mr. Chairman. I think that helped, but so if today a person murders a pregnant person and the infant dies, is there any additional charge other than the murder of the person carrying the infant?
Representative Oakley.
Thank you, Mr. Chair. Thank you, Representative Washut. What there currently is a sentencing enhancement. So in 62109, there is additional punishment. So not for murder in the first, which is a mandatory life sentence. So the sentencing enhancement for first is not included in 62109. There is for murder second, murder in the second degree is currently min 20 up to life. The sentencing enhancement that currently exists in law would make allows that for it to be 40 to life. And then there's 2 others that involve manslaughter and drug-induced homicide. And those, again, have a sentencing enhancement. So rather than being up to 20 years, it could be a min 10 up to 30 years. So 3 crimes are included for a sentencing enhancement. This is different in that it creates, of course, its own separate charge.
Thank you, Representative Oakley. And Chairman, if you don't mind, I would like to add, and I think my brain just had a little dump here. On the sentencing enhancement, there is a little caveat. You had to know the woman was pregnant. And in this case, there's not, you don't have to have that knowledge.
Representative Yin and then Representative Zwanser.
Thank you, Mr. Chairman. Senator, thanks for joining us on the side of the building. Appreciate it. So we're basically making a new version of murder in the second degree, 62104. And the sentencing enhancement, one of the applications is also enhancing 62104. So if you're guilty of this version of murder in the second degree, can you also get enhanced penalties on that murder in the second degree as well? So is it possible that you'd have 2 murder charges, the pregnant person and the new murder in the second degree plus the sentencing enhancement on top of that? Is that what would happen in that situation?
Mr. Chairman, I think Representative Oakley wants to answer that one as well.
Okay, Representative Oakley.
Thank you, Chairman. Thank you, Representative Yin. And I would say yes, that could be possibly what you'd look at, that it would be authorized if you kept, if this were to pass and the sentencing enhancement were to continue, I would say that's possibly a policy choice for the body, but it is possible then that there would be for killing, like, let's say murder, this would have to be murder in the second. That right now, that exists, so it would be a 40 to life. And with this, if you pass this, they could also be found guilty under 62104 twice. So have two, it would be possible to have two consecutive cases of 40 to life. Yes.
Representative Lawrence.
Thanks. A couple questions. So in that last scenario, person's carrying twins, triple sentence?
Mr. Chairman, I believe so. And one of the things I'd like to kind of reiterate, just to kind of help people balance this out in your mind, because this is what several people have had to do when they bring this up to me, and you can tell me if I'm right or wrong. Let's just say you were to burn down someone's house. You're going to be charged with arson, but Jimmy and Susie are in the house. You're going to get a dual homicide charge as well. If only one person's in the house, you'll get a charge of one homicide. So you do have to look at it like that. If you're going to kill somebody, it shouldn't matter how many people you kill, you're going to get that many charges. And I think that's totally justified.
Follow
So,
up, Representative Lawrence.
I guess a couple more. But the way the statute's read now, you don't have to kill someone. You just have to say that you were planning, or they have to prove that there was intent there for first or second degree, right? They don't have to die. They could be injured, or you could, have a premeditated act and it didn't get carried through. So I want to make sure I'm correct on that.
Mr. Chairman, no, you are incorrect in that. You do have to kill the child. So let's just say you're attempting first-degree murder on the mother, and you kill her and the child. You're going to get dual homicide charges, not convictions necessarily, but charges. If you only kill the child, then you're going to have only one charge of murder, because the mother may survive, but the child doesn't. Do you see what's going on?
Well, and
I'm not
Representative Oakley,
sure I
doesn't
do.
this statute cover attempted murder as well? I think is what.
Thank you, Mr. Chair, and I'm
Representative
sure
Lawrence's
that's what
question is.
Representative Wannister's getting at, which in this does have. So it does reference back to, like, let's say first-degree murder, and you can be convicted of first-degree murder or attempted first-degree murder. So, but you would still have to be found, guilty of the of the attempt, but attempted is included, yes. I do think that's an interesting part of this bill, and I saw some discussion that actually in some ways that what this would do is fill that gap if you consider it a gap, which is, so if there's an attempt on the pregnant woman's life, and because of that attempted murder, and I think that's really important to keep in mind. There's some discussion that there's not an intent here, but both of these reference either first degree murder or second degree murder, and then the intent is included in that. So the person does have to have the intent to premeditatedly and maliciously kill a human, or to purposely and maliciously kill a human, first and second. So there is an intent, there has to be an intent. This would fill a gap that somebody could be charged with a murder charge if, while in that attempt to kill the woman, they don't succeed, but the child dies. That's something that doesn't exist in our law, that they would be possibly, if found beyond a reasonable doubt, guilty of murder.
And so one more follow-up, yeah, go ahead. But you don't have to prove that either the person who killed or even the woman knew she was pregnant. So a woman is murdered. She may be 2 weeks along in the autopsy, whatever. They find out she was pregnant. Woman didn't even know, man didn't, or well, whoever killed person didn't know. Sorry, didn't mean to be sexist. You could still be charged with a double homicide, even if the perpetrator nor the victim knew the victim was pregnant. Would I be correct in that under this statute?
We can both do it if you don't
Go
mind.
ahead.
Mr. Chairman, Thank you, Chairman Zwaniter. I appreciate that question because it is so important that we visualize someone is committing a crime here. They are trying to murder or they're murdering or attempting to murder someone. And whether they were pregnant or not should not even play into the whole situation. When the autopsy comes up, she was pregnant, then you're charged with a dual homicide. Thus, the fire, when you go into the fire and you find a body in there, thus you're charged with the murder. Same kind of scenario. You don't have to know. You don't have to know that the woman is pregnant to when you commit murder and the baby dies as a result of the murder that you've just committed. If that makes sense.
Thank you, Mr. Chair. Thank you, Representative Zwaniter. The answer to your question is yes. The way this is written does not have, like the sentencing does have that the person had to know. So that would have to be something addressed at sentencing. This is that technically they could be that they did this intent to murder. So then guilty there. This could tack on another one, I guess. So it really does come down to a policy discussion or choice, I think, at that point. And I think what's really important that sometimes doesn't get understood or whatever, there's such vast discretion in sentencing for the sentencing judge. A defendant would clearly have counsel. So first of all, you'd have to have a pretty zealous prosecutor. I think if going, okay, well, I've got this technicality that they were 2 weeks pregnant, but we admit nobody knew about it. We could tack on another one. But also then you have to get through a judge that would then decide there isn't a single murder sentencing or any big sentencing that every single thing isn't put on the table and given for consideration from all sides and then a judge taking it into. So while yes, that is a technicality that could happen. And again, and I think that's part of the policy discussion and choice. Do I really see, where you're going to get, and again, first degree murder, let me throw this out there. First degree murder in the end, if they're convicted of the first degree murder, the woman for either murder or attempted murder, it's life in prison, mandatory life in prison. So you're not really going to get anywhere there. So you're talking about murder in the second degree. And there could be enhanced penalties here, certainly. But again, I think you're talking about a court system that would take all of that into account anyway. It's my thoughts.
Just to clarify, Representative Oakley, you said, so guilty of murder in the first degree is automatic life in prison. You're just saying that's the likely outcome. They'd still be death penalty eligible.
Mr. Chairman, yes, nothing about this, I guess, relates to that. That's still on the table as the law is now, yes.
Yep.
I guess one thing I would like to say in talking about this being a policy choice, Senator Hutchings talked about this, and there really is a domestic violence phenomenon, and it's not just, clearly up to and including murder, and it's been studied for a long time. There is a significant increase in domestic violence against women who are pregnant. I think what you're looking at here is, while we've talked about the knowledge of whether they were pregnant or not, and that it might catch somebody who didn't know that. In general, I think that's what this is looking at, which is getting a hold or having enhanced penalties for this phenomenon that we know exists, that violence up to and including murder is higher with pregnant women. And what this is looking at is a way to show in policy and in statute and to recognize. So if that's the case, then we are seeing that there's knowledge of of increased violence against pregnant women, and that this policy choice here is in recognition of that.
Just kidding. Representative Yin.
Thank
Please.
you, Mr. Chairman. So I think like Representative Zwanitzer, I want to make sure that we avoid unintended consequences or things that we don't necessarily want to make the policy decision on. And one of that is, so please tell me if this is plausible, because I've never been pregnant, so I don't know.
Thank you for clarifying that.
You're welcome.
Representative Yin.
For the murder in the first degree addition, where it says the person kills or attempts to kill any human being. So if a woman tries to commit suicide and is pregnant, will she be guilty of murder in the first degree if the suicide attempt, even if it doesn't kill her, kills the fetus? Thank you, Mr. Chairman.
Ooh.
Either one of us, Mr. Chairman, I'm going to attempt, because I think that's kind of getting off into the weeds. If a woman tries to attempt suicide and does not, and she kills her unborn, she's guilty of murder. And that's the way we have to look at it. Why would she want to do that? Who knows? But you have to include that. And then again, the way I look at it, and I could be wrong, Mr. Chairman, Representative Yin, the judge, the prosecutor, the DA, they all have that discretion to decide how they want to make that charge. But this would, to me, include that.
We got a tack on there, Representative Oakley, please.
Thank you, Mr. Chair. I do think that the suicide is an interesting thing, but I have to say, I do not believe that it's here. And it's because first of all, again, it ties back, both of these tie back to the original charge. Murder in the first degree is purposely and with premeditated malice killing a human being. I do not believe that suicide fits under that statute, that you would be committing murder in the first degree on yourself. And as I sit here, I am unaware of ever, I did not do any research, but as I sit here with a decade of experience, I'm unaware of anybody ever being charged like with attempted murder on themselves for suicide, which is what would have to happen here. First, they'd have to be found guilty of attempting to purposely and with premeditated malice be trying to take their own life. And I don't think that fits.
Representative Zwanitzer.
Mr. Chairman.
Oh, yep. Senator Hutchings.
Thank you, Mr. Chairman. Representative Yin, that's why she's my sidekick today, to help me out. Thank you.
It's nice having your lawyer.
Very nice.
I wouldn't want to see the bill. Representative Zwanitzer.
So, and I know we keep throwing what ifs at you, but I think this is a legitimate one. And I'm trying to like the bill. I really am, but I have two more questions. The first is, a woman finds out she's pregnant. Maybe it's rape or some other thing. You know, we have one clinic, I think, in all of Wyoming. She doesn't want to do adoption, whatever it is. If she terminates her own pregnancy, this law wouldn't apply because she would have to basically attempt to kill herself as well. But if she's just trying to eliminate the pregnancy, that would not fall. Is that correct?
Representative Oakley.
Thank you, Mr. Chair. Thank you, Representative Zwanitzer. And yes, I would say that's absolutely, I do not see any way in which that scenario is at play here. And I recognize that would be a concern to people. So I really do not think this is something that slips through the cracks and ends up being related to that, because so in looking at the bill in both, for example, page 2, looking at, so lines 13 through 23, notice that it's subsection D,
That's how I read it, Mr. Chairman. I just really wanted someone of the law degree to agree with me.
So, okay, but so let me just quickly, so line 20, specified in subsection A. So again, in subsection A, it goes back to that premeditated, purposeful and premeditated malice tries to kill a human being. It absolutely, both of them completely tie back to the statutory language of murder in the first or murder in the second as a prerequisite before then these three things also have to be met. 1, 2, you'll notice that both of these on Romanettes 1, 2, and 3, there's an and there. So after being found guilty of, one of those, then they also have to fit 1, 2, and 3 for this to be a second charge.
Sorry, one more, and it's more
no.
philosophical, but if either one of
It's
you would
good.
like to answer. Wyoming, just historically, we have kind of drawn a line in the sand on giving a fetus personhood or rights. And that's a long standing, even with the situation that happened a decade ago when we had that enhanced penalty. That was as far as the legislature at that time took it. Very emotional issue, right, for many members in the House, including me. And because we knew the circumstances and it was tough. But that was still kind of as far as they pushed it, because at that time we were not willing to, I guess, extend personhood rights onto a fetus. And that's what this allows. I mean, not exactly what you're asking for, but indirectly it does. And I'm just, any thoughts on that? I mean, is that, I don't know how, do you recognize that fact and that's
Right.
where you want to go with the bill? And
Mr. Chairman, both Mr. Chairmans, I appreciate that question because I've heard that. And this is I'll preclude my answer with the meaning in this bill, and I said it at the very beginning, is first and second degree murder. The meaning is exclusively and vested in the author of the bill. Regardless to how people are going to read or comprehend it, I can't help that. But the meaning is to give not personhood, but to allow the charge of first and second degree murder against the life that is within the mother. Not saying it's a person, it's the life within the mother. And even though I know it's a person, I'm not trying to make personhood. There was a case in, Teton, where a gentleman named Eric Olson went over to Idaho, just a
No
few miles.
relation to Chairman Olson.
Pardon me?
No relation. I just want to point out.
This is a
no-
OHLSON,
Oh,
just in
gotcha.
case, and I'm glad you clarified that. Went over to Idaho to kill his girlfriend. And he stated the same thing. Idaho, thank God, has the dual homicide law already enacted. And he says, hey, the fetus doesn't have any rights. Well, he's sitting in jail in Idaho right now with a dual homicide conviction. So we have to get over that. That's my personal answer. Now let Representative Lawyer Oakley answer the legal way.
Representative Oakley Esquire.
Yes.
Thank you, Mr. Chair. And specifically, I think to the statutory question that you're asking, Representative Swanser, there are protections, I would say, statutorily in this not to bleed over to other statutes, which is the concern and can certainly be the concern. And this is why at this point I can tell you that is because these are new definitions. So there's two, the unborn child and child in utero. And they do not show up anywhere else in Title VI. So as of this point, if this were enacted, they only apply because they're defined and they're used only in these statutes. So they can, this doesn't bleed over to fetus or child used somewhere else in the statute. So it would have to be a new law that then referenced and used these in order for it to apply to any other area of our statute. So that's a protection, if you will, as far as bleed over there. In anticipating this, one of the things I did think, or is that we could possibly put the definitions rather than, this is added to the definitions in 61104. So the beginning definitions in Title VI, that we could put them specifically under, like in subsection D, under 62101. So we could add that specifically, the definition underneath where we use them. But the reality is, in the end, again, it would have to be a new law or something different in the future referencing these for that to matter. So in the end, I don't think that gets us anywhere. But as it is, because unborn child isn't used in anywhere else, or child in utero, they are specific to these statutes at this point.
Thank you, Mr. Chairman, for all that.
You bet. I'm gonna go to Representative Provenza and then Representative Yin.
Thank you, Mr. Chairman. Thank you, Senator and Representative, for being here today. There's the courts, so the Ninth District Court has said that, has overruled cases in which a woman has been found guilty for harming her unborn child because she used drugs. And what the court ended up ruling was that the seminal issue this case presents is whether a fetus is a child for purposes of Wyoming's child endangerment statute. Ultimately, the court ruled and dismissed that case because fetus is not a person. And so if we put these laws in, how are we contending with court rulings, with Supreme Court rulings, and are we going to face litigation if someone is found guilty of homicide of a fetus? And what is that going to cost us?
Representative Oakley.
Thank you, Mr. Chair. Thank you, Representative Provenza. The difference here, and it relates back to the question that we just talked about with Representative Zwanitzer, and that's things are defined. And so what that is in relation to is child and the definition of child. And so that ruling, that discussion was, is it child endangering to ingest methamphetamine? And that is specifically like, no, because child is defined as a person who is born. So he declined to extend that to fetus. That's addressed here because specifically, again, unborn child and child in utero are defined in the statutes and not used elsewhere in the statute. So it's narrowly connected to the bill as it's brought.
Are you, Representative Oakley, you're familiar with the case that we're discussing with Representative Provenza? I just thought I heard Representative Provenza say it was a Ninth Circuit Court case.
She did.
That's what
Mr. Chair,
confused
yes,
me.
I am. Mhm.
It is a Ninth Circuit Court case, but it
Yes,
came out of a
is.
Wyoming Supreme Court decision.
That's correct.
And this, okay.
But again, I think, and in having some of these discussions, that was something that was interesting to me at first in looking at that. And that is why these definitions, because that specifically referenced child. And so what that is, and it would probably be Supreme Court cases too, Wyoming, so I'd go look. But child is defined as, a born person already. So that is a human being, and they declined at that point to extend that to fetus. But that is, I would say, addressed in the definitions of this bill.
Okay, Representative Oakley, I think I'm there. I think it was just a slip in words. I think Representative Provenza said Ninth Circuit, and she meant Ninth District.
It is
Which
Ninth
is-
District.
So I heard Ninth Circuit, so I was thinking an appeal to the 10th Circuit Court would be the Court of Appeal from the Wyoming Supreme Court.
I've got
So-
you.
Okay, so that's why I was confused.
No, in fact, I can just say, what she's referencing, it was an opinion written by District Court Norman Young.
Okay,
So, yeah, not the
okay.
Ninth Circuit
Yep,
Court of
I'm
Appeals.
tracking now. Thank you.
Thanks. Yeah, it's good clarification.
Good catch.
Representative Craigo.
Thank you, Mr. Chairman. And this question could be for either of you. So my curiosity is, I think you said there's 30 some other states that already have a statute similar to this. What do the other states require as far as knowledge if any, of the pregnancy?
Thank
Senator
you.
Hutchings?
Thank you, Mr. Chairman. They are varied. I went through, in fact, I tried when I first brought this bill up to use Illinois. I thought they were as strict as you could possibly be. They vary. There are so many. There are 38 states and they all have differences. And they're all pretty awesome, really, when you sit down and read them. After this session, I'll let you, I'll send you a copy of those if you'd like. I'll send you all a copy if you like. It's too varied to go into. We'd be here for quite a while.
Senator Hutchings, so I think you may have mentioned this, where does the definition then of child in utero come from? Does it come from one of these other states?
Mr. Chairman, some of the other states have used it, but it's the federal law.
Okay.
Yes, sir. And when I talked to one of the DAs, they said they preferred that, so it would, they would have no problem with litigating it, if that's the correct phrase. And I do have some court cases as well from other states, Supreme Court, and this law holds up all the time.
Representative Yin.
Thank you, Mr. Chairman. So a drafting question, I guess, when we're talking about the definitions, since one of the definitions is literally just the reference to the other definition, why are there two definitions? And because I don't think child in utero is used anywhere in the bill except in the definition of unborn child, which is literally just a child in utero. So could we just simplify this bill and have the one definition, especially if it's the one definition that the DAs are most comfortable with, child in utero used throughout the bill? Thank you, Mr. Chairman.
Representative Oakley.
Child in utero, child in
Do
utero.
you,
Mr.
do you
Chairman.
have an answer for why we are using unborn child versus just child in utero or vice versa?
Mr. Chair, Representative Yin, I would say this, I have not been a part of all the work that Senator Hutchings has done as far as the, the back research on this, I guess, and I noticed that too. And then I thought in the end, though, you think simplifying things and unintended consequences, it's, I think, an attempt to limit and narrow and not broaden what unborn child means. And I think the concerns are exactly what Representative Swanitzer, as well as Representative Provenza, brought up, in that it's trying to make sure that this isn't used in a way that's trying to slip into other crimes or other concerns that have been dealt with by this committee. And so, obviously this ends up getting into pro-life and pro-choice discussions, sometimes even perhaps in ways that it shouldn't. And I think these definitions are trying to keep it out of that. That's my sense of it. I don't have all the history.
Mr. Chairman, and Representative Yin, I'd like to add to that. Her sentiments are exactly mine. I took this directly from the federal law, so that's the way they had it. And that's the way our Wyoming DA, one of them said, that's great. I had several look at it. They like that language. And that's why I put it there, giving them a chance to help create the bill in a way that would make it easier for them to deal with. So I'm kind of complying with what they want, because they're the ones who are going to have to deal with the law. Thank you.
Representative Yin.
Mr. Chairman, so I'm not arguing about the definition of child in utero. I'm just arguing why we have two definitions. Thank you, Mr. Chairman.
All right, let's get this ship over to public comment. Sounds like committee's satisfied with its questions for now, so we'll move into public comment.
I truly
go
want to
ahead.
thank you all, Mr. Chairman, and I really did appreciate all the questions. They were very good. Thank you.
Thank you, Senator Hutchings. Thank you, Representative Oakley, for serving as counsel. Senator Hutchings. All right. We have some representatives in the room. No, but welcome to the Judiciary Committee, Vice Chairman Duncan. And Representative Martinez, are you interested in testifying on this bill? Please come forward. And Representative, I just want to apologize. I may have butchered your name, Representative Romero Martinez. My apologies.
Thank you, Mr. Chairman, and Romero Martinez. It's hard to roll the R.
I can't say it as good as you.
Thank you. You did fine. I have some comments and some concerns, and I hope to be able to clear up a few items. More specifically to the, I don't want to muddy the water or get off the side road again, like we all have been in this crazy treacherous snow, but unborn child is primarily the term used to the child who's just not yet born. So it's been common use from federal all the way down to local states as unborn child. In drafting some legislation to protect the unborn child recently, actually yesterday, I also used the word unborn child. As we move forward, I think some of the best doctors and advocates for children are starting to use the word preborn, but just because it's more scientific or something, pre-op, post-op, preborn. So I went with unborn. If it's needed, if a comma splice is needed, unborn, comma splice, fetus, comma splice. A fetus is basically a fertilized mammal. So whether it's an egg, a human, Webster Merriam might say something to the effect of 8 weeks after conception. But I think most of us, well, at least I could speak from my experiences, I never heard the word fetus or zygote or any of that to describe a human being in my life until I was probably about 16 years old. It's my mother would always refer, Mira ella, John, and look at her, John, and that she is with child, to translate into English. And I asked her one time, why do you say she's with child? Well, because she is. In the scripture, it says Mary was with child. So even going back to our Judeo-Orthodox Catholic Christian history, whether you're a believer or a non-believer, that history of calling a child is a child. Preborn, I think, I just wanted to kind of make a comment to the point of that. I really just want to support this bill, and I digress. And thank you so much for your time.
Thank you. Questions for the representative? All right. We appreciate you making a stop into the Judiciary Committee. All right. Clarissa, do I have anyone with their virtual hand raised in the virtual world?
Mr. Chairman, we do. We have Christine Lichtenfels, so I will admit her to the meeting now.
Please, thank you.
Hello?
Hi, Christine. Go ahead and introduce yourself, first name, last name, and if you represent an organization, please let us know and then tell us what you want us to hear.
My name is Christine Lichtenfeld. I'm in Lander. I actually had prepared comments, but I want to actually address some comments that came along the way here. So I will just go forward with that. Well, let me see my notes. Sorry, my notes are a little off. I think there's a real problem with miscarriage and being able to, because studies show, and the Mayo Clinic will say it, and other studies that you can find, that the rate of miscarriage is between 10 and 20%, and likely more, they say, because many people don't actually mention it. And therefore, it's going to be very hard to prove to the criminal standard of beyond a reasonable doubt that a certain action actually caused the miscarriage. People have miscarriages all the time, sad to say. That is the reality of it. And I really worry about, again, sort of setting up a situation where we can have, an over energetic prosecutor, and we've already, a couple other issues have been raised as far as what can happen there with, as Representative Oakley herself said, vast discretion that's there. And that tends to be a problem in the criminal law when there's too much discretion awarded prosecutors and judges. It is actually the responsibility of legislators to make sure there isn't just a broad range so someone can pick and choose. So I have a concern there. Then there's the concern about, the issue was raised that there's domestic violence is the real concern, and of course, and especially against pregnant women, and that is, it's terrible. Domestic violence should never happen. If the concern is that domestic violence against pregnant women, then it would make sense that you'd have to know that the woman was pregnant. Otherwise, the domestic violence is just against a woman. So I really believe that if you're going to go forward with something like this, there should be a knowledge component of that. And I think it was Representative Zwanitzer who asked the question about, well, what about other statutes, other states, what do they do? And for example, North Dakota, which is close by, they, in fact, for murder of an unborn child at 12.1-17.1-02, a person is guilty of murder of an unborn child if the person A, intentionally or knowingly causes the death of an unborn child. And that's one of their important standards there. And I mean, it goes on and on, but so that there is a knowledge component there. Likewise, in both and going to another issue raised by one or two of you, I forget who it was, asked about how this would impact the pregnant woman in a situation where possibly if she committed suicide or something like that. Both the federal statute, 18 USC 1841, on which this mirrors, and yes, I am a practicing attorney, graduate of the UW College of Law. Both that statute and the North Dakota statutes, and I believe other statutes too, specifically exempt the pregnant woman as being able to be prosecuted under the statute. And they specifically exempt getting an abortion as being a basis for it. And, although one can say that, oh, well, it's carefully crafted right now so that it wouldn't happen. But as you know, laws are constantly being changed, and a tweak here and a tweak there. And you get someone, and I'm sure you've all felt that the courts have sometimes misconstrued what you were planning to do with the laws. Courts make decisions too. Much better to get it in the statute itself, saying this specifically does not allow any action against the pregnant woman, and it specifically does not consider abortion as being at all under the framework of this statute. And yes, we already have the issue brought up by the other representative. I'm sorry, I forget, Ramirez Martinez, or regarding that there is currently a proposed bill that is talking about an unborn child. So that is a concern that no, unborn child is not actually just restricted at this point, or could well not just be restricted to this statute. So I think there are an awful lot of things going on here that I think it really has to have a hold put on right now, have a few more things looked at. And I will say, and I know this isn't going to probably convince any of you, but as a woman myself, this really worries me, this whole, like, the way it's set up with not even knowing that the woman is pregnant. It sort of sets women between what age, 12, 11, and up to 60 or something like that. I mean, well, that top number keeps rising as people do other things. As a sort of a step where it, they're almost equal protection issues, because people are not, women, well, you're gonna have to assume that she's pregnant, because otherwise, if we did anything and she possibly, if I hit her and then, there could be murder on that. I really don't like that as a perspective, just as a woman. I don't want to be put on a pedestal or anything like that, but that's a separate issue. I think there are a number of these other points that a number of you have quite carefully brought up yourselves that I think should make it so you defer on this, you vote no at this point on this statute. Thank you very much.
Christine, I didn't get whether you were with an organization or not. Did you tell us that? Or you just?
I'm not necessarily testifying in that capacity. I do run, completely volunteer. I'm not employed by any organization at this point, other than the law firm I work for, which is a separate issue.
Perfect. Thank you. Questions, committee? No questions? All right. Thank you for your testimony.
Thank you.
Carissa, anyone else with their hand raised in the virtual world?
Mr. Chairman, we have Phil Armstrong next, and he just needs to turn on his video and his mic.
Clarissa, how many do I have with their, I don't have it pulled up.
Mr. Chairman, there are 6 other people in the waiting room, but they don't have their hand raised. So if they'd like to testify, if they could please raise their hand, that would be great.
Okay. Yep. If you're going to testify, I now see the number of attendees. Just raise your hand and let me know so I can kind of figure out how to get everyone in here in the next 30 minutes, if I can. Go ahead, Phil, introduce yourself, first name, last name. If you represent an organization, please let us know and let us know your testimony.
Mr. Chairman, thank you for allowing me to speak today. My name is Phil Armstrong, and I'm just here as a private citizen. I've been listening to the presentation of the bill so far in testimony, and it occurs to me that where the language comes up of unborn child in utero, if I'm understanding correctly, according to the district court, they didn't really want to deal with that kind of language when it came to like meth abuse by a parent, things like that. And then Representative Oakley had said that language, I believe she said, I'm paraphrasing, sorry, that language made it harder to prosecute in that instance because of the word child. And then went on to say that this language is only being used in this bill, even though, as we know from Representative Romero Martinez, that it's used in another bill. And Representative Oakley did state that this language would have to be carried over to another bill in regards to whether or not this leads to anything else as far as establishing personhood. So I guess in through all of that, we're kind of talking in circles here. So I don't see why, if this is only about somebody murdering a woman and her fetus dying, then why can't we simply just put in here that this will not apply to abortions in the future or suicide? What would it harm to have those exemptions? So I guess I'm asking that question.
Do you have further testimony?
No, I'm just interested in that question. After watching this testimony, I was wondering if that can be cleared up by the folks presenting this bill. And I'm raising it as an issue of concern.
Oh, I understand. I appreciate that. I guess the way that we would proceed with that, we don't take questions from the public, but it's possible that somebody else testifying may address your question. And if not, after I close public comment, I open the bill to discussion of the committee. And at that time, it's possible that a representative may address your question. So I do appreciate your testimony.
Well, I would say then that my testimony is that this bill, through its language and its identification as child in utero, then does in fact open the door later to establishing personhood in other legislation if this language is used, as Representative Oakley stated already. So I'm against this. I would ask that you vote against it because of that.
Thank you, Phil.
Thank you.
All right. And then thanks for joining us. Where are you joining us from?
I'm from Cheyenne.
Okay. And so not too far, but I really enjoy the Zoom feature because we get people all over the state that we may not have otherwise. But even if you're right here in Cheyenne, we still appreciate you joining us.
Thank you.
Thanks, Phil. All right, let's move to the physical world now. Anyone in the physical world wishing to testify on this bill? Yes, ma'am. Hey, sorry, Linda. Yeah, you got to light up that mic so then we can get you on the YouTube feed.
Got it? There. My name is Linda Burt. I represent NAREL Pro-Choice, Wyoming. I also, just as a personal note, do want to tell the committee that I am a domestic violence survivor. So this is something that is certainly close to my heart in terms of protection of women. Senate file, from my perspective, 96 is not about women, and it's not about protecting pregnant women at all. We have an excellent statute at this point in time that protects pregnant women. Part of that statute, as was mentioned prior to this, was an enhanced, a 40-year enhanced penalty for a man who attempts to kill or kills a pregnant woman. That is not a discretionary penalty in the court. The statute reads that the court shall impose an enhanced penalty for those crimes. So that 40 years is directed by the statute to the court for enhanced penalty. This particular statute that we have in Wyoming has been a very carefully crafted statute in order to protect pregnant women. I think Senate File 96 actually takes that protection away and dilutes it. And the reason I believe this is because I don't think Senate File 96 is about protecting women. I think Senate File 96 is about exactly what we have been talking about in terms of the definition of child. And when we talk about the definition of child in the statutes, and as has been mentioned, there's a reason that that definition is not currently in the statutes. When we look at unborn child and child in utero, that particularly is presented in that manner in order to give a fetus personhood rights. The secondary crime of murder of an unborn child specifically gives a fetus and any level of, at any state of development, those personhood rights. This is that camel's nose under the tent. And this is precisely what these bills are about, is a camel's nose under the tent. Once these become into our statutes, then the next step is to put them in those definitions in other areas of the statutes. Our current statute Murder in the first degree already allows for life imprisonment without parole. So, or life imprisonment and the death penalty or the death penalty. So a second sentence under Senate File 96 does not prove anything, or it serves no practical purpose at all. As has been mentioned, Senate File 96 does not require that either the victim or the perpetrator know that the woman is pregnant. This bill allows for the death penalty for an attempted murder that results in a miscarriage. And I think this was mentioned very clearly from the previous woman that testified. There are 1 in 10 of every pregnancies end in miscarriage, particularly early on in pregnancies. Those pregnancies, most of them, we don't know why they end in miscarriage. For one reason or another, there can be nothing that is apparent that caused that miscarriage. In a situation where there is an attempted murder, the murder is not carried out, there is a woman that miscarriage for one reason or another, we don't know that reason. This makes this law, this actually confuses the current law, and all the questions that were asked, I think, show how this confuses the current law. In the current law, this is easy to prosecute, it's easy to prove, and there is an enhanced penalty for that man or person who decides that they're going to harm a pregnant woman. This is a much bigger deterrent at this particular point in time. This is a huge deterrent in Wyoming. I know there was some testimony by the sponsors that someone had gotten 3 to 5 years for a murder of an individual. This would not happen in Wyoming. This does not happen in Wyoming when a pregnant woman is harmed or killed. This is not something that would happen here. And and I think that's exactly right, that it shouldn't happen here. I think that the enhanced penalty is exactly right. There should be an enhanced penalty for harming a pregnant woman. We heard testimony that this is one of the most dangerous times in a woman's life. I know that as a personal experience, that it's one of the most dangerous times in a woman's life. And I think this is the kind of bill that dilutes that deterrent that we have at this point in time. We have a well-written, well-vetted statute at this point in time that protects women. And I think that that's what we need to stay with in order to protect women. I don't believe Senate File 96 does that. I think it is only about providing for personhood and rights for unborn children. I think the testimony is pretty clear to that. And just as a final point, I will make that in something I disagree with. In terms of the definition, 2 definitions, someone asked that question, why do we have 2 definitions? I don't think those definitions narrow this at all. I think the 2 definitions broaden this. And when we look at child in utero, means a member of the species Homo sapiens at any state of development who is carried in the womb. That's very broad. And I think that's the point of that. And I think the point of unborn child and a second murder charge in this is the point of fetal personhood. And I think this is to lead to other statutes and other areas that can lead to policing pregnancy. We heard about the case where a woman has been charged because she did methamphetamine when she was pregnant. What we know about that is charging women with drug charges during pregnancy is probably the worst way that you can protect either the mother or her pregnancy. And what was said is we can't do that because we don't have this in the statute. This is why it should stay exactly like that. We shouldn't have it in the statute. We don't want to police pregnancy. We don't want to charge women. And from the way this is written too, when I look at it, I think that under this particular bill and the way it's written, I think a woman could be charged if she attempted to harm herself and she had a miscarriage. I think she could be charged with that under this bill. I don't think the bill is concise or tight. I think there's all kinds of areas that we can get into unintended consequences. The other thing that we talked about is that we can be charged with 2, 3, 4, 5, 6 different charges under this bill. And there's no practical purpose to that. It doesn't lead to anything. In the situation we are now, there is an attempt on a woman's life, there is a murder, there is an enhanced penalty of 40 years on every one of those charges. That's clear, it's easy to prosecute, and it's easy to provide evidence for. Stand for questions.
Committee? Ms. Burt, I appreciate your comments about a miscarriage possibly resulting in a death penalty sentence. Couldn't that issue be easily resolved by simply amending this bill under 6-2-101 and 6-2-104 to eliminate the death penalty as an offense for murder in the first degree and murder in the second degree?
Mr. Chairman, I think that's absolutely right. Although what I would say about this is I don't think this bill should be amended. I think this bill precisely for the reason I said, because I don't think it's about protecting women. I think it's about providing personhood.
Representatives want to answer?
Sorry, just quickly, Ms. Burt, you are wearing a lobbyist name tag, and I don't believe you said who you were with.
Oh, I'm sorry. I
No,
apologize.
she did in her opening.
I missed it. Who are you with?
Oh,
No, it is.
I'm with NAREL Pro Choice Wyoming.
That's who you're lobbying for. Got it.
Okay. Thank,
We
Mr.
need to
Chairman.
get Representatives want to answer more coffee.
Any other questions?
Further questions for Ms. Burt?
Thank you so much.
Oh, Representative Provenza has a question.
Thank you, Mr. Chairman, and thank you, Ms. Burt, for being here. Real quick, you did mention that you think in suicide scenarios that a woman who fails to kill herself and then could be charged maybe in murder in second degree. I'm wondering if you could point in that language specifically why, just for my clarity, is that because on line 16 on page 3, we're saying attempts to kill any human being?
Mr. Chairman, Representative, yes, that's precisely why I think that, because it attempts to kill any human being seems broad enough to include me attempting to kill myself as a human being. Thank you.
Thank you, Ms. Burt. Others in the room wishing to testify on this bill? Deacon Lehman.
Thank you, Mr. Chairman. My name is Mike Lehman. I'm representing the Catholic Diocese of Cheyenne. I don't have much in the way of testimony. Just want to express that we do support this legislation. And with that, would stand for any questions.
Questions for the deacon? All right.
Thank you.
Appreciate you. Gail, yep.
Gail Simmons, just testifying as a regular citizen from Sheridan County. My understanding is that there actually is a gap in our laws that this is intended to close. And that is, as I understand it, that unless the woman dies, that the loss of the unborn child, of the pregnancy, is not subject to penalty. So if the woman survives and the pregnancy is terminated, my understanding is that under current law, that it's a pass. It's not covered. So the good thing about this bill, if I'm correct on that, is that it closes that loop. So if the woman survives and the pregnancy is terminated, it actually addresses that. So in that case, I'm very much in approval of that. I would say that the language around personhood is very, very problematic, and I would recommend that the language be consistent with other existing language, rather than open the door on a bill that sounds like it's very, very necessary. So I would recommend amending those problematic out, but close that loophole, because it is not okay. Just because the woman survives, that her loss of pregnancy is not taken care of. I also have a concern about not knowing. If somebody's in an accident, you're at fault. You're driving too fast for conditions. Then you could be guilty of, say, second degree murder, I think, under this. And so this lack of knowledge is problematic, but the biggest problem for me is just the language around personhood. But we do need to close that loop. It should not require the woman to be killed in order for her not to have justice, for her not having a choice on losing that pregnancy. And I stand for questions.
Committee questions? One thing I have is it is somewhat up to debate whether citizens of or residents of Sheridan County are in fact regular, but that's another issue for another day. Thank you, Gail. Others in the room wishing to testify on this bill? All right.
Excuse me, Chairman Olson, I have a
Yes.
handout from Senator Hutchings.
Oh,
Would you like it now?
Yep. Please pass it around. That'd be great. Okay, let's go, Clarissa. Let's admit Mr. Barron.
Mr. Chairman, he has been admitted to the meeting.
All right. And if anybody else out in the virtual world wishes to testify, go ahead and raise your hand so we can get you into the count. And go ahead, Mr. Barron.
Thank you, Chairman Olson. I speak on behalf of myself in this particular matter in support of the bill. I just bring one point to the.
Sorry, Mr. Barron, gotta have you just introduce your first and last record.
Excuse me. My name is Joseph Barron. I'm a county attorney in Sundance, Wyoming. I speak not as I have before on behalf of the association, but I speak on my own behalf. And in that, I just speak in favor and support of this particular bill. I would just point out to the committee that there have been enhanced penalties for harming pregnant women for quite some time. I would just specifically point out Wyoming statute 6-2-502, which is the aggravated assault statute. And in that statute, you usually have to perform serious bodily injury to a person in order to be convicted of that crime. But the law has been on the books, and I don't know when it was originally on, but it was at least 2004 and probably before that, because I seems like I always remember it being there, is that the intentional or knowingly or recklessly causing bodily injury to a woman whom he knows is pregnant is a felony, whereas just causing bodily injury to a woman or another person is a misdemeanor, a simple misdemeanor. It goes from 756 months up to 10 years. So these enhancements have been around for quite some time. Thank you.
Thank you, Mr. Barron. Questions for Mr. Barron, Representative Yin.
Thank you, Mr. Chairman. Mr. Barron, so, I mean, I think I would like your opinion on the question of having the enhanced penalty on top of the second murder charge. Do you think it makes sense to have two murder charges and an enhanced penalty on both charges? Or should we make it so you should just have two murder charges and no enhanced penalty in that specific case, which is specifically the second degree murder charge case?
Mr. Barron?
Mr. Chairman, Representative Yin, I've never had to deal with this particular issue, so I've been trying to follow that out and see how that works out. But I do think that because of the different standards there, the one knowledge requirement and the other one no knowledge requirement, that it gives different options to prosecutors. In the testimony that, you don't get I won't say a reduced sentence, but you should get an enhanced sentence and the enhanced sentence should go up for the more people that die as a result of your conduct. And so I like to be able to have various options. And so I think this gives several options that would be available to do that, to look at both things. So I would guess what I would say, Representative Yin, is I would leave them both there just so that both options are available.
Other questions for Mr. Barron? Thank you, Mr. Barron.
Thank you, Chairman.
All right. I'm not seeing any other hands raised. Do we have any other hands raised in the virtual world? Anybody else wishing to testify on this bill in the virtual world? We're on. Nope. Senate file. I almost said House bill. Senate file 96. We're on Senate file 96, homicide amendments. Anyone in the physical world wishing to testify here today on this bill? All right. That being the case, I will close public testimony on Senate file 96. Committee, what is your pleasure? Moved by Representative Zwanitzer, seconded by Representative Oakley.
Maybe for the record, can I have Representative Oakley move it?
For the record, correction to the record, moved by Representative Oakley and seconded by Representative Zwanitzer. All right. Did you get that correction, Kay? Sometimes I'm not sure if I'm looking to my left or my right. Shouldn't say I would
I did
ever
get that,
confuse
thank you.
Representative Zwanitzer with Representative Oakley. Distinctly different color of jackets.
Can I have a question, Mr. Chairman?
Sure.
And it might be for Representative Oakley. So I just want to make sure I'm okay with this. If a woman's pregnant and you purposefully assault her with the intent to end her pregnancy, but not to cause her death, this would not come into effect because you would only have to be attempting to kill her and the child. But if you made the case that, no, for whatever reason, you had no reason to harm her, you just didn't want that child to be carried to term and did something intentional to kill that child, that would not fall under a first degree murder charge.
Mr. Chair, thank you, Representative Swanser. And I would say that is correct. And it's a great distinction, but because both of these actually go back to and are connected to either murder in the second or murder in the first, a premise is that you have to be found, you would have to be that you purposely and maliciously tried to kill the woman, or that you purposely and with premeditation killed or tried to kill the woman. So it has to be connected to that. And I think that's a great distinction, but yes.
And then can I make a motion, Mr. Chairman, on amendment?
Sure.
So it'd be page 2, line, I guess, 4, and just, I'm gonna combine those two clauses. So it would say, unborn child means a member of the species Homo sapien. So instead of saying unborn child means a child in utero and a child in utero means, just combine them into, so you'd be deleting what 19 and just putting it as one definition.
Moved motion to amend by Representative Zwanser and seconded by Representative Yin. Did you get the motion, Kay? Okay, try again.
If you don't mind,
It would be on line 4, just delete child in utero, and then on line 6, delete the 19 child in utero means. And then it would combine automatically.
so it would read just unborn child means.
A member of the species, yep.
Okay, thank you very much.
All right. Discussion? Yes, you discussed it. Other discussion on the amendment? Representative Oakley? Do you have any comments on this amendment?
No.
Okay. Question on the amendment? All those in favor of the amendment signify by raising your hand. All those opposed? I don't think that motion carried. All right. Other amendments on this bill? Yes, Representative Yin.
Yeah, I'll have an amendment of the bill, if that's appropriate. On page 4, I guess, I mean, I don't know where, bring in 62109A Romanet I and add, so right now it says for a conviction of Wyoming statute 62104, add subsection A, so it only applies to the non-murder of the unborn child. It only applies to the regular murder. So that way you don't, if I get a second, I can explain it, but.
Yeah, let's look for a second. Okay, you got a
So,
second.
Thank you,
Representative
Mr.
Provenza.
Thank you, Mr. Chairman. Yeah, so the explanation is if someone does second degree murder on 2 individuals, if this bill passes, that person could be charged with less than a person who is than a person who murders a pregnant woman. So you could have the enhanced penalties on 2 murders with a pregnant woman, then you wouldn't have the enhanced penalties on just 2 adult individuals that get murdered. So I just want to make sure that we have an even application of justice here, where we're not adding enhanced penalties specifically on pregnant women that we wouldn't enhance on murders of 2 individuals that are separate people.
Other discussion on the amendment? Nope. Question on the amendment? Oh,
Mr.
go
Chair,
ahead, Representative Oakley.
I'm sorry, will you just state it again? I'm not following. I don't know why.
Okay.
Sure. So, Mr. Chairman, in 62109, which isn't in the bill, it's not in the bill, right? So 62109 is the current sentencing enhancement statute, right? So in 62109 AI, it talks about specifically the enhancement on second degree murder, which is 62104. I want to narrow that to 62104A, which is the existing 62104, and not have it apply to 62104B.
Okay, further discussion on the amendment. Everybody understand the amendment? Conceptually understand the amendment?
Mr. Chairman, I'm happy to restate it because I know I can be confusing sometimes. So, Mr. Chairman, again, so if someone murders 2 separate individuals, I want to make sure that the sentencing would be similar to the murder of a pregnant woman, where we're not saying a murder of a pregnant woman is worse than the murder of 2 separate individuals, right? So if we have enhanced penalties on pregnant women, this would apply to both of those murders instead of, which wouldn't apply to the murder of 2 individuals. So you could have 2 consecutive life sentences on murder of second degree of a pregnant woman that you wouldn't necessarily have on murder of 2 individuals where none of them are pregnant. Thank you, Mr. Chairman.
Any chance you want to hold this over and have them bring that in written form?
I understand the amendment. Are we ready to vote on the amendment? All those in favor of the amendment signify by raising your hand. 1, 2, 3, 4, 5. All those opposed? 1, 2. Craig's hand is not up. 3, 4. Okay, that amendment carries.
Chairman Olson, could I meet with Representative Yin afterwards to get the
we
correct?
Will, yep, we will not let Representative Yin leave this room until.
Thank you very
Please
much.
get with Kay. And if we have to follow up on any, I mean, with LSO on that at all, we can, but I think conceptually we can at least get that, but if you can get it on her notes.
Mr. Chairman, I know the exact insertion, so I'm
Perfect.
happy to work.
Let's do that so her standing committee report can be complete. Okay, further amendments on this bill? Nope. Discussion on this bill? Question on this bill? All right, Kay, call the roll on Senate File 96, homicide amendments. Thank you.
Representative Crago. Representative Larson.
Aye.
Representative Oakley.
Aye.
Representative Provenza.
No.
Representative Williams. Vice Chairman Washut.
Aye.
Representative Yin.
No.
Representative Swanitzer. Chairman Olson.
Aye.
Mr. Chairman, you have 7 ayes. You have 2 noes. The noes being Representative Provenza and Representative Yin.
Thank you, Kay. Senator Hutchings, I suspect your co-sponsor, Representative Oakley, will floor manage this bill. Thank you.